morning viewers and welcome to the EduSat lecture in the Management and Professional Studies. Today we have with us Mr. Ashwani Siwal, who is an assistant professor at the University of Delhi Law Center. He has been dealing with the IPR related studies and we have been having several lectures delivered by Mr. Siwal and we have been enriched by his IPR related knowledge. Today also continuing this process, he will be talking about IPR related procedures that one needs to follow to obtain an IPR right in India. Also, he will be talking about what does one do, what are the benefits, what are the reliefs one can obtain, what are the remedies in case IPR right is infringed. So, we will move over to Mr. Siwal and continue this lecture.
Thank you very much, Unnati. Welcome viewers. As rightly elaborated by my colleague Unnati, that I will be discussing about the infringement, especially the patent infringement, because we have been discussing about the patent law, and in our previous discourses, if you remember viewers, I have I have exhaustively discussed about how to obtain the patent and who is eligible to file the patent protection, where to go for filing the patent application, and how to proceed with the formulation of the patent application. Exhaustively this part has been discussed by me in my previous discourses. I would like to recapitulate certain points in later stage, but our today's agenda or today's deliverable primarily would be to let my viewers know as to the point of infringement. In what manners a patent right can be infringed, or as to what are the manifestations of patent infringement in India. After discussing about the kinds of infringement or the patent infringement taking place that possibly can take place in India, about the patent owner's right of patent, I will move ahead with the reliefs and remedies available in the case of patent infringement. If one's patent gets infringed, then what are the remedies or the reliefs available for him to get his or her right restored in that situation through the court of law or through the intellectual property appellate board or through the controller, So friends, as I promised that I will be recapitulating certain points, I told you that in our previous discourse as well as in our earlier discourses, I have been telling you that patent procedure is called generally patent prosecution proceedings in India or everywhere in the world. Patent prosecution proceedings are exhaustive proceedings. It comprises many things in it. It does not involve only one thing, it comprises so many things in it. Starting from identifying who is eligible to file the patent, then moving ahead to the next step or the next stage, where to file the patent, and then again the next step is to identify and locate the office where one can file the patent application, and then when one should file the patent application, the most crucial question to my understanding. These are the questions that I have dealt with you exhaustively. Few points I would like to recapitulate and recall for my viewers' understanding and to make their pace so that we can jump to our today's discussion, where I will be discussing about the patent infringement specifically. Well friends, see, if you remember and recall properly, the true and first inventor can file the patent application. As per the section 6 and its language, section 6 explicitly mentions that true and first inventor is eligible to file the patent application. Then another person who can file the patent application as per section 6 is the assignee of the true and first inventor, or assignee of the assignee can also file the patent application as per the definition of the assignee provided under the definitional clause of Patents Act 1970. Then there comes another person, another category of the persons who can file the patent application or are having the eligibility to file the patent application. They are called legal representatives. So legal representative of the deceased assignee can also file the patent application. Friends, if you remember, I discussed with you who is the legal representative in the case of filing the patent application or becoming entitled to file the patent application in case there takes place the demise of the true and first inventor. Well, as per the definitional clause, section 2 of the Patents Act 1970, legal representative has been declared and expressed clearly that the person who represents the estate of the deceased immediately before the death of the person, or who is deemed as the representative of his or her estate immediately before the death of the person, is called the legal representative for the purposes of the Patents Act 1970. So friends, as we know that these are the people, these are the categories of persons who are eligible to file the patent application, the next thing that we need to see and that we must understand, where to file the patent application. I have told you in my previous discourse and in my earlier discourses that one needs to go to the patent office having the appropriate jurisdiction, or you can say having the territorial jurisdiction where one can file the patent application. So one needs to approach that particular patent office, that is called the Patent and Trademark Office, or you can say Controller General of Patent Trademark in India, where there are several offices. There is a nodal office for the same, and there are branches of the same having the territorial jurisdiction of different states, or encompassing different states under its territorial jurisdiction or under its ambit. Well, friends, once you locate and once you are done with this exercise of locating the appropriate office having the territorial jurisdiction where you can file and move your application, being eligible to file, being entitled to file the patent application as per section 6 or on the grounds of section 6, you should move to that office. Well, the next thing that one is or should be very curious about is going with the proper application, application formulated and formatted in a very good manner and perfect format. That is quite elaborate and exhaustive exercise to be done by the applicant seeking the patent protection. Friends, if you remember that I have shown certain forms and their particulars to be filled by the patent applicant while obtaining the patent protection. There are several forms which are for reference of the patent applicant while filing the patent application. Section especially 7 of the Patents Act 1970, and then we have patent rules of 2003. If they are read together, they are coupled together for the convenience of the patent applicant, and certain forms provided therein, then we get the wholesome format to file the patent application. That format has to be followed and complied by the patent applicant. If he or she does not follow it properly, then that may be problematic for the seeking of the patent protection or for the purpose of fetching the patent ultimately at the end of the day. The fourth exercise one should do, and the fourth step, which I believe is the very first, or should be the first, ideally should be the first step for obtaining the patent for the applicant, is about when to file the patent application. Well, friends, when it comes to when to file, as I have discussed with you in my previous discourses, that it is crucial for the patent applicant to identify the right and the appropriate time for filing the patent application, wherein I told you that the moment one conceives the idea about any kind of invention to come up with, or invention to be reproduced or procreated by that person, in that case it is supposed and expected from that person and ideally advised to that person that he or she should go to the patent office and immediately file the patent application with the provisional specification, because as per section 9 we have the a procedural and complete specification procedure available in the case of the patent proceedings or patent prosecution proceedings in India. So one can file with the provisional specification mentioning few details as per section 10.1 and 10.2 and 10.3 about that provisional specification. Later on, he is supposed within 12 months of time to file the complete specification for the same. When he files the complete specification for the same, he gets the patent protection if he has fulfilled rest of the qualifications for obtaining the patent. Well, that is all about the previous discourse, friends. And one more thing I would like to highlight at this juncture, because I believe that for today's discussion and today's discourse, it is highly crucial for all my viewers to understand that there has to be a invention over which a person will be seeking the patent protection, and that person who has created that work, who has invented that work, should conform or should comply with the right procedure provided therein under the Patents Act as well as under the Patent Rules 2003. only then he will be able to fetch the patent protection. Or you can say in nutshell that his or her subject matter over which he or she is seeking the patent protection should not have been expressly excluded from the purview of patentability, should not have been expressly excluded by purview of section 3 and 4 of the Patents Act 1970. Well friends, now coming to our today's discussion, as I have told you that one can easily obtain the patent by following this procedure as highlighted and discussed by me. The next thing that he or she needs to take care of is about enforcing the patent after obtaining it. Well friends, one applies for the patent. Fortunately, after following the proper procedure, he or she gets the patent, or say gets conferred with the grant of the patent by the government. Then he or she needs to be a bit cautious to protect his patent, because many rival competitors, or say many persons are involved in the same research, many scientists, inventors involved in the same research, maybe unauthorizedly try to use his or her work without taking the permission of the person, without getting transferred the patent. So in that case, that constitutes the infringement. So for that, or for knowing what all constitutes the infringement in the case of the patent, it is highly incumbent for the viewers to understand first of all what are the rights that gets conferred on the person after obtaining the patent in India. He has followed the proper procedure, his subject matter is suitable to be granted the patent. But now what is need to be seen here is about what are the rights will get conferred on that person after obtaining the patent protection in India. Those rights are to be seen and discerned by all the viewers, because only after knowing the rights of the patent holder, we will be able to understand in what manners and manifestations the infringement of the same can take place. And the remedies for the same can be understood only after knowing that infringement subsequently, or the reliefs available can be understood only after knowing the infringement of the patent, or the manifestations of infringement of the patent in India. Well friends, let us see the rights of the patentee in India. As per section 48 of the Patents Act 1970, certain rights the patentee obtains when he gets the grant in the form of the patent from the patent controller, from the office of the government, who is a patent controller in this context, in this scenario. There are certain rights which he acquires, which he gets on the filing of the patent and after the grant of the patent, ultimately after the grant of the patent. Let us have a look at the rights, all the rights which one gets after obtaining the patent protection. If you have a look at this slide friends, this section 48 is quite explicit about the rights of the patentees. It reads that subject to the other provisions contained in this act and the conditions specified in section 47. So section 48 is subject to the other provisions of this act and the conditions specified in section 47. A patent granted under this act shall confer upon the patentee. Friends, if you have a look, it is clearly mentioned that a patent granted under this act shall confer upon the patentee the following rights. What is the first right provided to the patentee under section 48 explicitly? It reads, where the subject matter of the patent is a product. See friends, if you have a look at this slide, I have categorically demarcated, highlighted the right of the product patent holder initially. 48A covers the rights which gets conferred on a person who is a product patent holder. It's not the case of the process patent holder, it's the case of the product patent holder. I would like to tell my all viewers at this juncture and at this point, and to explain this point, that there are the two kinds of the patent we have understood while starting the patent law through this medium, through this educational communication medium. I told you that the patent is of two types, product patent and the process patent primarily. There can be a product by process patent also, but we are concerned only with the product patent and the process patent. So one who obtains the product patent, one who is a holder of the product patent, he gets this right as mentioned under 48A. What is that right? kindly have a look at it. It says the exclusive right to prevent third parties. It is a right which is granted to the person, and it is an exclusive right to prevent third parties who do not have his consent from the act of making, using, offering for sale, selling or importing for those purposes that product in India. So friends, I would like to bring your kind attention here that one who is the owner of the product patent, or you can synonymously use another terminology to define that person having or possessing a product patent, you can say him in nutshell product patent holder. So product patent holder, as per this 48A, gets a right to prevent third parties from doing what? From the act of making, using, offering for sale, selling or importing for those purposes that product in India. I mean, nobody will be allowed for making that particular product, for using, for offering for sale, for selling, for importing that product in India. He cannot make, sell, offer for sale, import that product in India unauthorizedly without the consent of the product patent holder. He can never do the following specified acts under 48A. Well, jumping to the another right, I mean right of the process patent holder. Well friends, this right of the process patent holder vis-a-vis to the right of the product patent holder is little different. I mean the right conferred or which gets conferred after the obtainment of the patent is quite different in this case. If you look 48B friends, it reads that patent is a, in the case of the process patent, the right in the form of exclusive right to prevent third parties from the act of using that processes and from the act of using, offering for sale, selling or importing for those purposes the product obtained directly by that process in India. So the right, if you see granted or which gets conferred under 48B is little different with vis-a-vis to the product patent right holder given under or clearly mentioned under 48A in terms of what? That in the case of earlier, I mean in the case of 48A, the patent holder, I mean the product patent holder gets a right to prevent third parties. But in the case of 48B, he only gets a right from preventing third parties from using, offering for sale, selling or importing that process or any product directly obtained by that process. So what is the distinction actually? I would like to discuss it a little bit to make you understand that what is the real distinction between 48A and 48B in this context. Well friends, 48B as restricts itself only to the right of excluding the third parties from using that process and the product directly obtained from that process. Product directly obtained from that process. So what process is, sorry, what is the right of the process patent holder here by the purview of 48B is the right to restrict, is the right to preclude the any user, unauthorized user of that process, one thing. Another right that he gets is to exclude and preclude the user of the product directly obtained by that process. This is quite extended right or a wide right vis-a-vis to the earlier right, because earlier right was restricted only to what point? Only to the exclusion of the third party from making, using, selling or offering for sale or importing any that kind of a product in India. But here under 48B, if you see, if you have a look, this gives a complete wide right in comparison with the earlier right, because it does not only restrict the third party from using that process, rather it restricts the third party and it grants a right to the owner of the process patent holder to restrict the third parties from using that product obtained directly from that process. I will exemplify it for your convenience friends. Suppose I am a owner of one process, as I am a process patent holder of that process. When I use it, I have a right which gets conferred on me by purview of 48B as rightly highlighted by me right now. I have a right to exclude others from using that process without my authorization, without my consent prior taken by them. Another right that I get or that I am getting by purview of 48B in this context is to restrict the users of that product directly obtained from that process. So that is how it becomes a wider right in comparison to the right provided under 48A. Well, we will have a further discussion on that, friends. Don't worry if you are not comprehending it properly. I will repeat it for you in my later slides. The next thing that we need to understand, I mean the distinction only between these two rights of different stakeholders. In the one case it is a product patent holder, in the another case it is the process patent holder. Let us differentiate. Primarily you can say that this is the distinction between 48A and 48B only, but I have categorized it as a product patent holder and process patent holder. If you have a look at the product patent holder, he can stop a third party from making, using, offering for sale, selling or importing that product regardless of the process by which that product has been made. I mean, the product patent holder does not remain bothered about the process used to create that product. I mean, he has got a right over his product. He has created and invented that product by his ingenuity. Once he gets a patent protection on that particular product and he becomes a product patent holder of that particular invention, he can stop the third parties from making it, from using it, from offering it for sale and from importing that product in India. Nobody can do these specified acts without his authorization. They need to take the authorization from this person, I mean from the product patent holder. But see, it is regardless of the process by which that product has been made. I mean, he does not have any control over the processes available to create the same product. He can restrict the people from creating the same product. This is his right. From selling it, from making it, he can restrict the people. But he cannot restrict others from engaging themselves into creation of new processes to make the product. I mean, he does not have any control over his process. He has not got a patent over his process. He has got a patent over his product only. He owns a product. Say process is A to create one product which is B in this example. So he has a right only on the product B. He does not own any right on the process called A. So he cannot restrict anybody using that process A without his authorization. He has a right only according to section 48A to preclude the parties from using product B, I mean product in this context. He cannot restrict anybody using the same process which he has used to create the product. So I believe that is quite easy to understand for all of you. In case if you do not get it straight, I am available in my earlier lecture for my ensuing lectures. I will be available online as well. I mean through the mail you can contact me and write me down about the queries. Well, let us move ahead and see what are the rights of the process patent holder. What does the process patent holder gets when he or she gets a grant of the patent in the form of the patent? If you remember 48B as discussed just now by me, it says that the process patent holder can only stop a third party from using that particular process or from using, offering for sale, selling or importing any product that is obtained directly by that process. I would like to read it again for your convenience, friends. It says that the process patent holder can only stop a third party from using that particular process or from using, offering for sale, selling or importing any product that is obtained directly that by process. So as I mentioned, 48B vis-a-vis to 48A is quite wide in its ambit and in its scope, because it grants a right to the process patent holder to not only stop the third party from using that particular process, rather it grants a right to the process patent holder to restrict and preclude the person or any third party from using the product directly obtained by that process. I mean, he owns the process. In this case, he does not own the product as such, but he owns process. And if something is directly made by that process, he can stop the third parties from making use of that product as well. That is how we differentiate between 48A and 48B, and you can easily summarize that process patent holder is always in a win-win situation with to product patent holder, because product patent holder does not get that kind of a wide right which the process patent holder is getting in this context, because process patent holder is getting two rights. I mean, he has a right over the process as well as over the product directly coming out of that process, over which he has got a patent protection. So his rights are bit extended. Process patent holders' right are a bit exhaustive, as well as you can say are wider in comparison with the product patent holder. Well, I believe, friends, this is clear to all of you. See, 48 as per provides what? It provides the rights to the patentees, and there are two categories of patentees here. One is product patent holder, another is process patent holder. We have understood as to what the product patent holder rights are, and we have understood as to what are the rights of the process patent holder as per section 48A. After understanding these rights, one common notion that, or one general notion that you viewers should make, that he gets a right to preclude others. It is his negative right, it is not a positively worded right. The law as such nowhere grants him a right to make, sell, offer for sell. Rather, the law says or uses a negative connotation, asking him to preclude others or granting him a right to restrict others from doing so. Impliedly, he will be making, he will be selling, offering for sale, importing that thing in India. Without his authorization, nobody else can do so. But the point is, the law does not provide his rights in a positive manner. It always provides, or it provides it only in a negative manner. Negative in what sense? That he has a right only to exclude this, not getting a right through the purview of 48 to make, sell, or offer for sell, or manufacture, or you can say import that thing into India. Automatically, you see, he will be doing the same, because he has the right over the patent. He has whole freedom and all freedom to use and appropriate his property in whatever manner he or she likes. But the point is, law defines it in a negative fashion. It does not define it in a positive fashion. That has to be taken care of by all the viewers, that it is a negatively worded right under the 48 of the Patents Act 1970. Well, after understanding these rights, another thing we have to move is about the infringements or say kinds of infringement that may constitute. Well, friends, as you know that these are the rights of the patent holder. Once you know that these are the rights of the patent holder, it is very easy for you to comprehend and discern now that there can be many forms and manifestations of the infringement in the case of the patent holder's right. I mean, if somebody is unauthorizedly making use of the patented work, he is infringing. Or you can say, if somebody is unauthorizedly selling some patented product or a process, he is infringing it. If the third person or the third party, without any kind of a consent obtained from the patent holder, unauthorizedly importing it into India, he is infringing the patent. So there are several manifestations of the infringement, or you can say in several manifestations infringement in India can take place, or infringement at world level, I mean at large, can take place. So now, as we have understood the rights, we need to understand what are the remedies available for these infringements. I mean, several kinds of infringement that may take place of the rights, which are various rights available to the patent holder in this case, in this context. What are the different kinds of remedies available, reliefs available, or you can say what are the checks and balances embedded in the law in the Patents Act 1970 to curb that kind of a infringement to take place, or prospective infringements to take place. So we have, see, in the Patents Act, checks and balances embedded in it, or interspersed in the definitions, or in the, you can say in the provisions, in the various provisions of the Patents Act 1970. from where we can easily make out that these are the various mechanisms available for the restoration of the right of a person or for bringing a check or curbing at the initial level. I mean, one can easily stop anybody from obtaining a wrong patent because it may tantamount to somebody's patent right, already existing patent right infringement. So that is how one can easily stop that person in a manner of stopping him pre-grant or stopping him after the grant, I mean post-grant after the grant of the patent. In these two fashions, one can easily stop the person from obtaining a wrong patent. And what are the grounds? I mean, who can file these proceedings? What are the grounds available in that case, in this context? That we will see. Let us jump to the next section. I mean, opposition proceedings. So, who will be filing the opposition proceedings? I mean, one who is being victimized, I mean one who is feeling victimized or one who is being made a victim of some misappropriation or some wrong appropriation of the patent by somebody, and somebody is trying to obtain the patent, then in that case, or somebody has already obtained a patent erroneously, in that case, patent opposition proceedings are available. And these patent opposition proceedings are available at two stages, as mentioned by me just now, that at the pre-grant stage one can go for the patent proceedings, at the post-grant stage one can go for the patent proceedings. We will understand what are the grounds for the pre-grant oppositions and what are the grounds for the post-grant opposition. Both the things are very important and crucial for us to understand, because only then we will be able to understand the various checks and balances embedded in the patent law for bringing this kind of abuse or an exercise to halt or to stop that kind of abuse and misuse or appropriation of the patent of somebody else without the authorization of that somebody else. Well, if you have a look at section 25(1), it talks about pre-grant oppositions, and section 25 friends talks about post-grant oppositions. These two provisions are providing us the opposition proceedings, and these two provisions are very wide and written in a very exhaustive fashion, providing so many grounds to one to approach to the patent controller for getting it rejected, or you can say for filing the pre-grant opposition or post-grant opposition. And our task here is to do the threadbare analysis of these two provisions. We have to do the threadbare analysis of these two provisions. I would like to take you to the reading of section 25 friends. That reading is very crucial, because with that reading only we will be able to understand as to what are the different kinds of grounds available under 25(1) and 25(2) for a person who is thinking of opposing somebody's patent. Let's have a look at 25(1) friends. If you see your slides, or if you see on the screen, 25(1) especially provides about the, or talks about the opposition of the patent. At what stage? At the stage of, you can say, pre-grant stage. It is about stopping somebody at the pre-grant stage. Let us have a look at it, where I am just starting to read this and going to threadbarely analyze 25(1). Well friends, 25(1) reads, where an application for a patent has been published but a patent has not been granted. So two things which are noticeable from the very first sentence of section 25(1), that application for pre-grant opposition can be filed only after the patent has been published but patent has not been granted. Only after the patent has been published. Friends, if you remember the procedural aspects for obtaining the patent, I told you that the person applies for the patent protection, he requests for the examination of the patent application, and the patent controller publishes the patent application to let the people know, to let the stakeholders know that this kind of a patent application has been placed and put before the patent office for the grant or for the conferment of the patent. So after the patent publication and before the grant of the patent, finally any person, friends, as highlighted and demarcated by me, 25(1) reads any person may. It does not restrict the purview as to who all are eligible or entitled to file the pre-grant oppositions. Rather, it keeps it open. It says any person, I mean whosoever. Any person here means whosoever. It is not restricted only to an interested party, or it is not restricted to only to a competitor. Rather, it allows any person to file the opposition to the controller against the grant of the patent. And there are several grounds given on which, or by making or invoking these grounds the base, the person can file the pre-grant opposition. But there is a time frame when he is eligible, or he can, or ideally he must file the patent pre-grant opposition. That is the time when the patent application has been published but patent has not been granted. I mean, it is in the process. Application is in the process of conferment of the patent. Patent grant has not been done finally. It's in the process. Only an application for the patent has been published, and now the oppositions are coming in writing by stakeholders or by any person. I mean, let us see what are the grounds available to that person who is thinking or of filing the pre-grant opposition. These are the several grounds available. If you look at 25(1)(a), if somebody wrongfully obtains an invention and goes for filing the patent application on that wrongfully obtained invention, he should not be getting the patent protection. But that factum, or that factum about the wrongful obtainment of the patent by him, is not into the cognizance of the patent office. If somebody brings it, I mean any person in writing lets the patent controller know that this patent seeker has obtained it wrongfully. He is not the true and first inventor of this application, he has wrongfully obtained it and seeking a patent protection. Then he can be curbed through the pre-grant oppositions, though undoubtedly he will be given a chance to be heard. I mean, he has been provided with the full and wholesome opportunity to defend himself or to negate the allegations leveled against him. But still, this is how the Patent Act 1970 intervenes at many junctures or at many points into the final grant of the patent to the patent seeker. It is not that easy to get a patent. There are several things. I mean, when your patent application will get published, many patent stakeholders or any person, I mean, who will be feeling prejudiced, or who will be feeling some sort of resentment about the obtainment of the patent or to be conferred to you, he can approach the patent office in writing and let the controller know about the lacuna in your patent application, let the controller know about drawbacks in your application in the form of wrongful obtainment. First of all, the first ground that we have read is about what? That one who is seeking the patent, the seeker of the patent has wrongfully obtained the patent and he is not suitable and eligible person to be granted the patent protection. If this fact gets established and proved before the court of law, or you can say before the controller, after laying down certain or adducing certain evidences, the patent controller may turn down his application and will not grant him the patent protection. Well, 25(1)(b) furnishes another ground. It reads that the invention so claimed by the patent seeker has been published before the priority date. It is already published. I mean, something which is already published will never make a novel claim or will never get the patent protection, which we have understood way back our discussions relating to the substantive requirements for obtaining the patent. I discussed with you the novelty requirement, and I told you novelty postulates what all to be seen. It postulates about something which is anticipated, something which has already been into the public domain, something which has been published somewhere will never make novel or will never be called or deemed novel work. So in that case, one has to do what? One has to disprove it that his work or her work is novel. But if somebody labels an allegation through the pre-grant opposition proceedings or by invoking 25(1)(b) as a ground that your work in this case or in this context is a work which has already been published, then if it gets proved, it will be really difficult for the seeker of the patent to fetch the patent protection. His application will be turned down or striked out by the patent controller, and he will not be giving the patent protection. Well, friends, if we move ahead and see the next ground mentioned under 25(1)(c), it is the ground which says if one files the patent application and he thinks that his patent application is the one which has been filed, surpassing other patent applications, I mean surpassing in terms of earlier date, if he believes that his application has been filed on the previous date, on the first date, and on the date when nobody else has filed the application for obtaining the patent, and if it gets disproved, or if somebody alleges that his patent application with a complete specification is not a patent application on the priority date, rather somebody's else patent application on the same claim is on the earlier date than the applicant's claim. So then in that case it will be really complicated for him to prove or to establish that his invention or his claim is the one which fetches the priority date, is filed earlier than that of the others. And if others are able to prove that their application has been filed earlier to that of the original applicant, I mean the present applicant's claim, then they will be getting the patent. I mean they will be at least successful in getting it turned down from the controller, and the controller will make it a base and will deny the patent protection if his application is not on the priority date, is not earlier than that of the other applicants. Another ground, I mean very interesting ground friends, it is 25(1)(d). It says if the invention claimed was publicly known or publicly used in India before the date of that claim, before the priority date of that claim. As we all know that if somebody's work is already published, already publicly known or publicly used anywhere, then in that case, friends, his or her work will never be what? It will never be a work qualifying the test of novelty, or it will never be a work rising to the merit of novelty. It will be denied the patent protection. So one can make it a base if he or she does have any kind of evidence that this work is already known to the people, this work is publicly known, is used in India. I would like to quote one recent case law wherein our court has turned down one claim of one yoga guru, claiming that he owns or he was seeking the copyright protection on his yoga postures or say yoga techniques. He was denied the right, and it was specifically and categorically mentioned by that court that yoga has been into the tradition, has already been into use, or people are enriching themselves with these techniques and yoga as an exercise since times immemorial. So one person will never will be able to fetch the intellectual property protection on that particular technique. Here in this context, if somebody's work is already into the public domain, is already in use, he or she will never be able to vindicate his claim of the patent or for the patent. If alleged or if it gets alleged by somebody, by the competitor, by any person, by any stakeholder, by anyone, then he will not be getting the patent. His patent will be rejected through the PreGrant Opposition. Well, the next 25(1)(e), another ground for the PreGrant Opposition, friends, it reads that if somebody's work or somebody's claim with the complete specification is obvious and clearly does not involve any inventive step. If somebody's work is obvious and clearly does not involve any inventive step having regard to the matter published. Well, friends, I would like to bring your attention here about the inventive step to be involved in the work and the discussions that I made about the inventive step as one of the most important and pertinent qualification for obtaining the patent in India. See, if somebody's work is not involving or possessing the inventive step, or if somebody's work is just obvious work, is a work which is clearly does not involve any inventive step, something which is known to Fosita, which is known or obvious to the person who is ordinarily skilled in that art, he will never be able to get the patent protection, and this can be made a ground to get his patent application rejected, because the patent has not been granted yet. We are talking and discussing about the stage where the patent has not been granted. It's a pre-grant opposition time. even during the process of the application or its processing, one can go to the controller's office in writing and make these many grounds, or out of any of these grounds, one of the grounds can be invoked by him for the cancellation of his application, for the turning down of his application. I'm not saying that he has already got a grant, I mean he has already fetched a patent. Even if he fetches a patent, even if he is able to or successful in getting the patent, it can be later on opposed under 25(2), which are called post-grant oppositions. But as right now we are discussing about the pre-grant oppositions. Well, let us move ahead, friends. 25E is over. 25F furnishes another ground for the pre-grant opposition, and it reads that if the subject of any claim of the complete specification is not an invention within the meaning of this act or is not patentable under this act. I believe it is very easy for all my viewers to understand that something which is not a subject matter for the patent. If you remember section 3, which provides what are not inventions, a list has been provided or is given what are not inventions as per section 3. So if somebody's work is falling under section 3, or if somebody's work is a work which is non-patentable, does not have the patentability, in that case his patent application has to be denied the patent, or his claim has to be denied the patent. But if the patent controller does not come to know about it on his own, though it is his duty to peruse the subject matter over which the person is seeking the patent and threadbarely analyze and meticulously analyze and gauge it, whether the subject matter over which the patent is being claimed is a subject matter or not, or is a appropriate subject matter or not. But the point is, if he moves ahead with the processing of the application and forgets to see it, or may unfortunately does not get to see the subject matter, does not gauge the subject matter qualification by the application filed by somebody in the form of the pre-grant opposition, he has to check it and he has to provide the opportunity to the patent seeker as to how his claim involves a patentable subject matter. If he fails to prove it that his claim is not a patentable subject matter, his patent application will be turned down, his patent application will never see the day of light, will never be granted the patent protection. Well, the next is, which is kind of a procedural requirement to be fulfilled by the person. If you remember section 10, I told you that there are some particulars which are to be accompanied, or which are to accompany the patent application in the complete specification. If one does not provide those particulars in a clear and sufficient manner, one may face a huge trouble in getting the patent protection. So if you look at 25(1)(g), friends, it reads that the complete specification does not sufficiently and clearly describe the invention or the method by which it is to be performed. As you all know and remember, I hope and I suppose, that best mode disclosure is one of the sine qua non for obtaining the patent. Best mode disclosure or best working method to be disclosed is one of the indispensable requirement for the person seeking the patent. If one fails to show the best mode, if one fails to establish or provide the best working of his invention or his work known to him, in that case he may not get the patent protection, because he has failed to comply or conform with the procedural requirement as provided and stipulated under section 10 of the Patents Act, because he is not providing it clearly as to how his invention or his work will function, his work will be able to facilitate others involved in the same research, in the working of that research. So in that case, patent controller will entertain the pre-grant opposition proceeding on this ground and may reject the application for the patent, will never grant the patent protection to that person. Well, friends, moving ahead, if you look at 25(1)(h), it says, if the applicant has failed to disclose to the controller the information required by section 8 or has furnished the information which in any material particular was false to his knowledge. If I would like to tell you about section 8, well friends, section 8 is about the foreign applications, and there are certain disclosures to be made by the person while making the foreign applications, and if somebody does not comply with section 8 or does not obligate with section 8's mandate, then that applicant will never get the patent protection, and on this ground, on what ground? That he has failed to furnish or to disclose to the controller the information required under section 8. Anybody can challenge and anybody can file or go to the controller for the pre-grant opposition, and the controller, after establishing this fact that he has failed to disclose the information as required and stipulated under section 8 of the Patents Act 1970, can turn down his application, will never grant the patent to the person. Another requirement, friends, it is provided under 2(1)(I). It is a requirement where the applicant or you can say the application was not made within 12 months from the date of the first application for protection for the invention in a convention country by the applicant or a person from whom he derives title. Well, it is about the convention application, friends, and if the application was not made within 12 months time period after the first application for protection for the invention was made, then in that case there may be a trouble and the pre-grant oppositions can be filed. So you can see it further while we will discuss about the convention applications. If you look at 225(1)(j), it says that if the complete specification does not disclose or wrongfully mention the source or the geographical origin of biological material used for the invention. Well, friends, this can also be one of the grounds for pre-grant opposition if the patent applicant's claim involves a biological material in it, if his invention involves a biological material in it, and if he disclose the biological material, it is a mandate for him to disclose the biological material. But if he fails to disclose the biological material properly, as written here, if he does not disclose or wrongly discloses, wrongly mentions the source or the geographical origin of that particular biological material, in that case it becomes or it furnishes a good ground for any person to go to the patent controller and file for the pre-grant opposition. Because I would like all of you to remember section 10 and subsection 4 of section 10, where it has been stipulated explicitly that whenever it is a case of the invention involving a biological material, the applicant filing the complete specification needs to disclose the origin of that biological material and the geographical origin, geographical place from where that biological material has been taken. If he does not disclose it, if he wrongly discloses or mentions about the place and origin or the geographical origin of the biological material, in that case he may be facing a lot of hardships and trouble in getting the patent application, because any person can restrict him or can get him restricted, precluded from fetching the patent protection from invoking this ground under the pre-grant oppositions as provided there under section 25. Well, friends, another important ground which section 25(1)(k) furnishes for the person seeking or feeling like approaching the controller for the pre-grant opposition, it is the ground where the complete specification is already anticipated. Well, friends, this ground is quite easy to comprehend and discern by all my viewers, that whenever the applicant fails to disclose the complete specification properly, because section 10 especially through subsection 4 requires the patent applicant to disclose the information in a very proper and solid manner, sufficiently and clearly. But if he fails to sufficiently and clearly describe the invention and its best mode, and if he fails to enable the posita, person who is ordinarily skilled in that art, then in that case, it may become a ground tomorrow for the pre-grant opposition, and the person's patent application or claim may get turned down by the patent controller. Here, if you look at 25(1)(k), it says if the complete specification is already anticipated. If somebody's work is already anticipated, it means what? That it has already come to the public domain, it has fallen to the public domain, it is known, it is in use, either being used here in India or somewhere else in any part of the world. In that case, friends, he will not be getting the patent protection because his complete specification is not genuine, is not authentic, and he will fail on that front. His patent application will be turned down. Well, friends, that is all about 25(1), and I would like to recapitulate certain points as today's takeaways for all of you. I have discussed with you, a very important and crucial procedure for obtaining the patent. I have discussed with you what constitutes the infringement of the patent in India. I have discussed with you the rights of the patentee. Especially you need to remember section 48 of the Patents Act, which encompasses many rights of the patentee. We have seen that there are two kinds or two categories of the patentee in India: product patent holders on the one side and process patent holders on the other side. We have differentiated between these two kinds of patentees in India. Another thing that we have done in our today's discourse, we have understood under section 25 that a opposition proceeding is one kind of a relief or a remedy available to the person seeking to curb the wrong person claiming for the patent application, or seeking to curb the wrong person filing the patent protection application. There are several grounds enumerated and specified under 25(1), which I have threadbarely and meticulously analyzed with you. Well friends, I rest here and I promise you to discuss the rest of the things. I will jump to 25(2), which covers and encompasses post-grant oppositions. The grounds are quite similar, but there are certain differences to be noticed by all my viewers, which I would highlight in my ensuing discourse. So I rest here. Thank you very much. Good day.
Thank you very much, Mr. Ashwani Siwal. This was a very intricate discussion. You had gone step by step, section by section regarding the IPR laws, the procedures and infringement issues. Thank you so much, sir, for this enlightening and energetic talk by you. We hope to continue this discussion with the future lessons. Thank you.